Yes. I'm just kind of preparing myself because it seems that nobody has called my phone or responded. Yeah. I sent about 3,000 emails today, and informing law enforcement, right, of this whole question of when is it that must be heard. Now, it's probably something that a lot of attorneys don't think about, but let's say, okay, you're on trial, and you do one of these: order dismissing misdemeanor charge, competency restoration treatment, unsuccessful or unlikely to be successful. Yeah. Now, by the agreement of the parties, okay. The report of the competency evaluator, who is a professional person as defined in RCW 1077.010. Yes. Now it's 2:15, and I got here about 5 minutes ago. Yeah. Now, when I was reading this, okay, because I know a lot of those in law enforcement are like, well, when do you have to tell the guy that he could change his counsel? Yes. Now it says, even when counsel is found to be competent, it has been found that a conflict between counsel and a defendant that cannot be resolved would create a situation where the defendant is being denied the right to counsel. In Daniel versus Woodford, it was found that when a court refuses to appoint new counsel after a defendant has completely lost trust in their attorney, that defendant is thereby effectively thereby constructively denied any counsel whatsoever. Now, this question of when an attorney makes a motion for determination as to whether or not a criminal defendant is competent, a Marsden motion, must be heard before the competency hearing known as a Section 1368. Yes. The competency hearing. Yes. Now, is that before the evaluation of a professional person where I would say I would like to have new counsel? Right. Because I don't need a mental health evaluation. I actually do understand the nature of the crimes against me. Yes. The court finds following based on preponderance of the evidence, the defendant is charged with a misdemeanor crime of violation of a protection order. Now, this same misdemeanor crime is where the violation date took place at 7:47 a.m. on December 31st of 2015. Yes. And 4:48 p.m. on December 31st of 2015. Yes. When I was on the bus that morning. Yes. And I was in the library that afternoon. Yeah. And I had the email to prove that I was in the library. Now, exactly must be heard before the competency hearing. Yeah. Now, I'm thinking Mr. Roberts is saying, well, actually, the cell hearing is the competency hearing. Yeah. Now, People versus Stankiewicz held that although criminal proceedings must be halted during a hearing for competency, yeah, a Marsden motion is not a criminal proceeding and must be heard first. Hearing a Marsden motion during a competency hearing does not reinstate competency proceedings against the defendant. That would be from the People versus Stankiewicz. Yes. Now, when do you have to hear the evidence that would convict the person of the crime before having a competency hearing? But the attorney actually thinks that there is some guilt or there is not some guilt. Now, I know, Jack, he said, well, you're having a 1077. Is the competency hearing after you ask the incompetent, do they know where they was at on June 16th of 2017? Now, this whole idea, okay, that you're going to charge me with these 2-count criminal complaints, yes, violent crime per se, coach, and then I inform you that, well, Actually, I wasn't in Sequim, Washington. Oh. And then you say, well, you've got to be charged with a crime. hmm Now let's look at the case in Jefferson County. You arrest me for a 2-count criminal complaint. Yes. Where I had informed law enforcement that I wanted to know what was the what was the case about in Jefferson County before you had the court date August 21st of 2017. There wasn't anybody that wanted to investigate why am I named as a defendant. Yes. Now, I was video arraigned with Judge Landis on the 19th day of September of 2017, almost a full year ago. Ooh. Now, it happens to be P. Budnick 21 that I emailed the police department. So exactly when is it that you inform the accused of their right to have a change of counsel? Is it at the time that you think that there needs to be a competency hearing? Or is it after the mental health evaluation? Or is it after the evidence that they could have actually committed a fucking crime? Now, I'm going to sue the fucking shit out of every individual in this nation that has an illegal obligation to make sure no one is accused of a crime when they have the evidence that they didn't commit a crime. And then I'm going to sue you for not informing me that I had the right to have counsel before the mental health evaluation. Will you make a determination that there's a question of competency? Now, when you really consider the mental health evaluation that took place while I was in jail, I said there was no jurisdiction because I wasn't in Sequim, Washington. Yes, I was in Port Angeles, Washington, all day long on December 31st of 2015. Now, for the dumb fucking cops that think that I'm really